All right, I'm showing 9 o'clock, so good morning. This meeting is called to order. Mr. Trotman, has anyone signed up for public comment?
No, sir, we have no registrations for public comment this morning.
All right, thank you. Ms. Miller, are you there?
Good morning. How are you?
Well, I'm well. Good morning.
Thank you.
We'll be under agenda item 3 now, and I'm showing that we have no cases to reconsider under agenda item 3. Is that correct?
That is correct, sir.
Well, then let's move to agenda item 4. We'll now consider tax liability cases under agenda item 4. I believe we have tax cases on both dockets 16 and 17.
Yes, sir. On docket 16, the first case is TD-19-125-1019. Commissioner Dimerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
The second case is TD-19-142-1219. Commissioner Dimerson?
1 second. That case is here, number 2.
TD-19-142-1219.
Chairman, I don't have that one. Ms. Miller, I don't have that one.
I don't have it either.
Yeah, neither I.
Okay. Then let's move on to the next one.
The first one was good.
TD-20-020-0220.
I agree with staff recommendation.
And Commissioner Alvarez?
I agree with staff's recommendation as well.
And Mr. Chairman?
Agree with staff recommendation.
All right. And the last case on docket 16 is TD-20-021-0320. Commissioner Dimerson?
I agree with staff recommendation.
And Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
I agree with staff's recommendation.
Thank you. Moving on to docket 17, there are 3 cases. Case number 1 is TD-20-013-0120. Commissioner Dimerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
The second case is TD-20-018-0120. Commissioner Dimerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
And the last case is TD-20-019-0220. Commissioner Dimerson?
Agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
Thank you. That was the last case on docket 17.
Great. Agenda item 5. We have no fair housing cases under agenda item 5. Is that correct, Ms. Miller?
Yes, sir, that is correct.
All right. We will now move to agenda item 6. We have no wage claim cases pulled for additional discussion on docket 16, and we have 1 on docket 17. Is that correct?
Yes, sir, that is correct. The case on docket 17 is case number 19-055-375-2. Commissioner Alvarez?
The decision should be affirmed. The employer established good cause for their non-appearance. Regarding the wages owed, at the time of separation, the parties signed an agreement which attempted to address the payment of commissions after separation. The terms of the agreement were unclear. However, for 8 months, the employer paid commissions that the claimant earned after separation. The parties' performance during this 8-month period is sufficient evidence that the employer had agreed to pay the claimant all commissions earned after separation. As such, the claimant was entitled to $34,377.32 in wages owed. Affirmed the WCAT, employer had good cause, $34,377.32 in wages owed.
The AT decision should be modified as recommended by staff. I agree that the employer's non-receipt notice of the first hearing gave the company good cause for missing that hearing. Concerning the issue of commissions, the claimant's resignation letter was ambiguous with regard to the issue of payment of commissions following the work separation. Although the employer agreed to and did make some commission payments following the claimant's last work date, such payments were done at the employer's discretion out of goodwill and did not constitute a binding promise to continue to pay commissions for an indefinite time after the work separation. Accordingly, we should modify the AT decision as recommended. The employer had good cause to miss the first hearing. The claimant is not entitled to additional wages.
And Mr. Chairman.
Affirm the WCAT. Employer established good cause for AT1, $34,377.32 wages owed.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson. So that was the last case pulled for the wage claim cases. You should already have received the short form dissent lists for wage claims on docket 16 and 17.
Move we accept staff recommendations on the remaining wage claim cases on dockets 16 and 17.
I second the motion except for those cases on which I am dissenting, as reflected on the wage claim short form dissent list for docket 16 and 17.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the wage claim short form dissent for docket 16 and 17.
Motion passes with the exceptions that are noted.
Thank you, sir.
All right, let's move to agenda item 7, in consideration of employment insurance cases. On docket 16, you can proceed when you're ready.
Beginning with case 244-1264, Commissioner Alvarez.
The claimant was let go from her job because she was absent from work for a few days to assist her daughter during a family emergency. The claimant had worked on this same assignment for 3 years. Under section 201.01121 of the Act, temporary employers send employees on assignments during employee absences, temporary skilled shortages, and seasonal workloads, special assignments and projects, or other similar work situations. Given the length of assignment, this agreement was not temporary in nature. Section 207.045H of the Act should not be applied. The employer claimed that the claimant was let go from the assignment due to absenteeism, but they provided no real information about her absenteeism. The employer did not meet its burden to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The AT decision should be affirmed. The claimant testified that she did not read the employer's reporting policy and she did not contact the employer for reassignment as required. Thus, she quit without work-connected good cause, and we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case 245-2145, Commissioner Alvarez.
The AT should be reversed. The claimant returned to work during the benefit week ending August 24th of 2019. Under Appeal 2722-CA-77, a claimant with a return to work date within 6 weeks is no longer required to search for work. The claimant should not be held ineligible for failing to produce a work search log for the benefit week, during which he was not required to search for work. The claimant's appeal should be deemed timely, and the reporting ineligibility and overpayment should be reversed. Reverse the AT, deem appeal timely, reporting eligible, no overpayment.
We should affirm the appeal tribunal decision. Because the claimant failed to check his online correspondence on a regular basis, his appeal was not timely, and we do not have jurisdiction to consider the underlying merits. We should affirm the AT decision. The claimant filed a late appeal, reporting not eligible July 28, 2019 through August 3rd, 2019, overpayment of $507.
And Mr. Chairman.
Yeah, affirm the AT, untimely claimant appeal, reporting not eligible July 28, 2019 through August 3rd, 2019, overpayment.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case 245-5034, Commissioner Demerson.
The appeal tribunal decision should be reversed. The final incident consisted of the claimant hitting a client's garage door with his vehicle, which resulted in the employer having to reimburse his clients for hundreds of dollars in repairs. In addition, the claimant's contention that he was working to the best of his ability is not credible. The claimant admitted in testimony that he was not paying attention to what was going on behind him and was looking at a forklift in front of his vehicle. As a result, he hit the client's garage door. The claimant's admission that he was not paying attention is not consistent with working to the best of one's ability, and even if it were, the basic duty of keeping a proper lookout when operating a vehicle is so straightforward that the claimant's failing to do so was work-connected misconduct. The claimant received previous warnings for prior infractions, and the fact that the employer chose the client's garage door damage as the final incident does not make the separation one of convenience or any less of a misconduct level event. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. The employer had a disciplinary policy which calls for a verbal warning, written warning, and probation and probation prior to discharge. The claimant was not given probation prior to his discharge. The final incident was minor damage to a garage door. Because the employer failed to follow its disciplinary procedure, the evidence is insufficient to establish misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case, 245-7408, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant was scheduled to work on the day of the final incident. In fact, the presented evidence that the claimant assured the employer she would work on the day of the final incident because she had been given time off the previous Friday. Nonetheless, the claimant did not show up for work as scheduled, did not report her absence to the proper individual, lost track of time due to personal reasons, missed the employer's attempt to contact her, and only returned the employer's call after missing part of her shift. During this call, the employer has consistently maintained not approved to take the day off. The claimant should have known that she could be discharged for refusal to come into work since she was asked whether she was abandoning her job. The phrase abandoning your job is enough to reasonably conclude that a job separation is one's future for failure to comply with the instructions that accompanied said phrase. As such, the claimant's refusal to come into work as scheduled was a clear refusal to follow instructions and misconduct connected with the work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. The employer has a progressive disciplinary policy that includes a verbal, written, and final warnings before discharge. The claimant was also discharged for a single absence without having received any prior warnings. The claimant's discharge without proper treatment under the employer's disciplinary policy was not for misconduct. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Demerson.
The next case would be 246-0082, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant did not return to her job in order to move with her spouse from the area where she worked. This type of job separation results in a disqualification per 207.045C of the Act. Although the disqualification is temporary, it remains a disqualification and is the equivalent of quitting without good cause connected with the work. Quitting without good cause connected with the work is an exception from the duty to pay reimbursement per 205.0125A2 of the Act. In addition, finding the employer not liable for a reimbursement would be consistent with appeal tribunal decision 247-1350-1-1, which contained a similar fact pattern. As such, the employer's account should not be billed. We should therefore reverse the AT decision, reimburse the employer, not billed.
I would affirm, as the claimant separation was not a complete disqualification, the reimbursing employer should be billed.
Reverse the AT, reimburse the employer, not billed.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case will be 246-2975, Commissioner Alvarez.
The decision should be reversed. The claimant was absent from work with notice when her elderly mother fell down the stairs and was admitted to ICU. Consistent with precedent 502-CA-76, the claimant's absences were with proper notice and were for compelling personal reasons and therefore not misconduct connected with the work. Reverse AT, no misconduct.
The claimant's absence from work constituted mismanagement of her position of employment, and we should affirm the AT decision. Misconduct, void the chargeback ruling.
Affirm the AT, misconduct, void chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case is 246-4457, Commissioner Demerson.
We should grant a rehearing in this case. The hearing was continued in part to allow the employer to submit 2 documents, the claimant's termination and a handwritten statement the claimant provided to the employer regarding the final incident. Although the employer provided these documents for the second hearing, the AT failed to admit these documents into the record and did not question the parties about them. In the handwritten statement, the claimant alleges facts which completely contradict his testimony. Because these documents are relevant and the claimant's credibility is at issue, we should grant a rehearing for admission and consideration of the evidence and with his inconsistent statements.
The decision should be affirmed. The painting task was assigned to a group of people. The claimant was off work for 3 days immediately after the task was assigned and was fired shortly after returning to work. As the claimant was not at work, he was unable to complete the task. Additionally, the task could have been completed by anyone else in the group, and the employer did not explain why the claimant was singled out. Therefore, the employer has not shown misconduct. Affirm the AT, no misconduct, chargeback.
Rehear.
All right, I have a majority vote to rehear the case. Commissioner Demerson, part of your vote broke up. You wanted the rehearing to address inconsistent statements by the claimant and documents submitted by the employer?
Yeah, because these documents are relevant and the claimant's credibility is at issue, we should grant a rehearing for admission and consideration of this evidence and to confront the claimant with his inconsistent statements.
Thank you, sir.
Thank you.
Next case will be 246-4873, Commissioner Alvarez.
The claimant was let go from her job because the organization she worked for decided to terminate all contract workers. The claimant had worked on the same assignment for over 6 years. Under Section 201.01121 of the Act, temporary employers send employees on assignments during employee absences, temporary skill shortages, seasonal workloads, special assignments, and projects or other similar work situations. Given that this assignment was not temporary in nature, Section 207.045H of the Act should not be applied. The employer's client let the claimant go for reasons that did not constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The AT decision should be affirmed. The claimant did not report for reassignment in accordance with the employer's policy, which the claimant acknowledged. Thus, she quit without work-connected good cause, and we should affirm the AT decision. Voluntary leaving, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form.
Thank you. I have a short form dissent for Commissioner Demerson.
Next case is 246-4959, Commissioner Alvarez.
The claimant appeal to the commission in this case should be deemed timely. The claimant mailed his appeal to the correct address on the last day to file a timely appeal. The appeal was then faxed to the commission appeals. While the fax number from which the appeal documents were forwarded is not a recognized commission number, that does not matter. The envelope in which the claimant mailed his appeal was a part of a fax transmission and demonstrates that the claimant mailed the appeal correctly, but it was nevertheless misdelivered. Someone then forwarded the appeal to the commission appeal by fax. Whether the appeal was forwarded by TWC office is immaterial. The claimant mailed his appeal by the deadline, and the appeal should be deemed timely. Deem commission appeal timely and resubmit on merits.
Because the claimant did not elect any exception to the timeliness rules, nor did he assert any delayed or non-receipt of the AT decision. The claimant's appeal is not timely, and we do not have jurisdiction to consider the underlying merits. Accordingly, we should dismiss the claimant's appeal as late and leave the underlying AT decision in full force and effect.
Timely commission appeal, resubmit.
Thank you. We will resubmit the case.
Next case is 247-2232, Commissioner Demerson.
We should modify the appeal tribunal decision. I do not dispute the availability decision. As to the job separation, the claimant, as funeral director, should have never engaged in any hugging or kissing behavior with the subordinate at the workplace. The claimant's position of authority subjects the employer to strict liability for claims of sexual harassment. The subordinate's actions are not relevant here, but the claimant's actions are. It was reasonable for the claimant to be held to a higher standard. Thus, because the claimant crossed the boundaries of professionalism, admitted to kissing the subordinate on the lips after she had told him that such behavior was not appropriate, the claimant missed his position of employment. We should modify the AT decision, misconduct, no chargeback, adequate employer response. The claimant was available for work.
The decision should be affirmed. The claimant had no prior warnings for the behavior that led to his discharge. Additionally, the greater weight of the evidence indicates that the coworker gave the claimant conflicting information about what she desired. Therefore, the employer has not shown misconduct. Regarding the availability issue, since the claimant was out of town for a professional conference, he was available for work. Affirm the AT, no misconduct, chargeback, claimant available for work.
Modify the AT, misconduct, no chargeback, adequate employer response, claimant available for work.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case is 247-3717, Commissioner Demerson.
We should rehear this case. The claimant was discharged after being a no-call, no-show due to the claimant's arrest. Although the claimant alleges that the criminal charges were dismissed, she has provided no documentary evidence of such dismissal. The claimant's release from jail does not equate to her charges being dropped. Because the finding of misconduct hinges on the disposition of the criminal charges, before we render a decision in this case, we should grant a rehearing to allow the claimant to provide documentary evidence corroborating her allegations that the charges were dismissed.
I would affirm the claimant reported for reassignment. However, the employer chose not to reassign her because of the allegation that the claimant was dishonest. However, the claimant informed the employer that she had been arrested and explained the circumstances. As a greater weight of the evidence indicates that the claimant provided the required information to the employer, the claimant should remain qualified for benefits. Affirm the AT, no misconduct, chargeback.
Rehear.
Thank you. We will rehear the case. That was the last case pulled for additional discussion on docket 16. You should have already received the short form dissent list for docket 16.
I move we accept staff recommendations on the remaining UI cases on docket 16.
I second the motion except for those cases on which I am dissenting, as reflected on the UI short form list for docket 16.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the UI short form dissent list for docket 16.
Motion passes with the exceptions noted.
Thank you, sir. Moving on to docket 17.
Beginning with case 243-8893, Commissioner Demerson.
The AT decision should be reversed. The claimant was discharged for conduct which violated several laws and company policy. The claimant denies all wrongdoing. However, a careful review of the evidence in this case clearly establishes that the claimant mismanaged his position of employment. An employee testified firsthand that the claimant made him pay for 2 beers out of his own pocket, which was a violation of federal wage and hour law. Another witness testified that the claimant admitted to that conduct and since admission against interests constitute an exception to the hearsay rules, the testimony from these 2 witnesses outweigh the claimant's denial. Furthermore, since the claimant is not credible with respect to that issue, the claimant is also not credible when he required the employee to take the beers home with him. That employee provided firsthand testimony that the claimant told him to take the beers home with him on the evening of the final incident. This violated the Texas Alcoholic Beverage Commission rules and regulations and was an immediately terminable offense under company policy. As an assistant manager for almost 10 years, the claimant should have been well aware of the rules. The weight of the evidence in this case establishes that we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The claimant was discharged for allegedly violating the employer's rules and TABC's rules when he made an employee pay for beers on an open tab and allegedly told the employee to take the beers home. The claimant has consistently denied telling the employee to take the beers home, and the employee in question testified at the commission rehearing that he did not in fact take the beers from the employer's premises. The preponderance of the evidence established that the claimant did not violate the employer or TABC rules, and he was not discharged for reasons other than misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form.
Thank you. I have a short form dissent for Commissioner Demerson.
Next case will be 244-5187, Commissioner Demerson.
The AT decision should be modified. I do not dispute the finding on the good cause issue, but the conclusion on the job separation is not supportable. The claimant was discharged after he was discovered unconscious in the employer's parking lot with drug paraphernalia in his vehicle. This violated the employer's drug-free workplace policy. The claimant denies drug use, but this is not credible. First, the claimant's denial is outweighed by the testimony of two first-hand witnesses. The testimony and written statements from these witnesses revealed that the police showed them the drug paraphernalia before confiscating it, which consisted of a glass pipe and a Coke with burns on it. This goes in line with the claimant's statements, as he admitted that he later went to the police department to collect his personal items. Police would not have been involved in this scenario if the claimant had only suffered an unknown medical issue. Further, the claimant did not deny that the paramedics revived him by administering a drug that is used on those who overdose. Based on this evidence, there was no need for the employer to drug test the claimant, and the employer has proven by preponderance of the evidence that the claimant violated the employer's drug policy. We should therefore modify the AT decision. The claimant had good cause for his non-appearance, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. I agree that the claimant had good cause for the non-appearance at the AT1 since he never received the notice of hearing. On the separation, the claimant was fired for violating the employer's drug policy. The claimant was never tested for illegal drugs and has denied illegal drug use. The employer did not meet its burden to establish misconduct by the preponderance of the evidence. Affirm the AT, claimant had good cause for the non-appearance at AT1, no misconduct, chargeback.
Affirm the AT, claimant established good cause for AT1, no misconduct, chargeback.
Short form.
Thank you. I have a short form dissent for Commissioner Demerson.
Next case will be 245-2825, Commissioner Demerson.
The AT decision is not supportable and should be reversed. The claimant's initial statements are self-disqualifying. The claimant was discharged after a trainee under his supervision dumped hot asphalt onto the cab of a truck, which could have seriously injured the driver of the truck. In his initial statements to the commission, the claimant admitted that he was supposed to be watching the trainee, but he failed to do so. Since the other employee was still in training, the claimant had an obligation to ensure that it was safe to dump the asphalt, especially because the claimant had received a prior warning for a similar incident. Moreover, it is no defense that the trainee allegedly stated that he could do it himself. The claimant was still obligated to supervise his trainee's work until the training period officially concluded. The claimant's conduct placed the safety of others in serious jeopardy, and he mismanaged his position of employment. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The claimant was discharged because a newly hired employee accidentally dropped asphalt into a truck. The claimant was overseeing the coworker. The employer had demonstrated an understanding of the process, and the employer has not provided evidence that the claimant was responsible for the accident. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form.
Thank you. I have a short form dissent for Commissioner Demerson.
Next case will be 245-6946, Commissioner Alvarez.
The decision should be reversed. The claimant was upset following a disagreement with her supervisor. A co-owner saw the claimant was upset and told her to go home early. The co-owner then gave the claimant a ride home because they carpooled together. As the claimant followed the owner's instructions, the owner's directions, her leaving work was not misconduct alleged by the employer. Reverse the AT, no misconduct.
We should affirm the appeal tribunal decision. Participating in a disruption at work and leaving work early, the claimant mismanaged the position of employment. We should affirm the AT.
I'm sorry, Commissioner Demerson, could you please repeat your vote? You broke up.
I'm sorry about that. We should affirm the AT decision of misconduct.
Thank you. Mr. Chairman?
Reverse the AT, no misconduct.
A short form.
Thank you. I have a short form dissent for Commissioner Demerson.
Next case will be 245-8801. Commissioner Alvarez.
The decision should be reversed. The claimant was supposed to have the services of a secretary to assist him in completing his job functions. The time period in which the employer complains that the work was not completed adequately overlaps with the time in which the claimant was without the assistance of a secretary. The claimant was performing to the best of his ability, given that the employer was understaffed. The evidence is insufficient to establish misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
We should modify the appeal tribunal decision. Documentary evidence established that the claimant did not carry out his duties as assigned. Because the claimant had been warned of lack of compliance, his continued failure to meet standards and constituted misconduct connected with the work. We should modify the AT decision. Misconduct, reimbursing employer, not bill, sever the adequate response issue.
Modify the AT, misconduct, reimbursing employer, not billed, sever adequate response.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Alvarez.
Next case will be 245-9856. Commissioner Demerson.
The appeal tribunal decision. The claimant quit her job in order to accept a voluntary separation package. The precedent case cited by the appeal tribunal is distinguishable from the case before us in two significant ways. First, the precedent case stated that layoffs were imminent, which is not the situation in the present case. Indeed, the employer testified that the claimant's replacement was still employed. This also establishes that continuing work was available for the claimant at the time she voluntarily resigned. Second, the individual in the precedent case would have lost all benefits had they not signed the severance package. By contrast, in the present case, the employer testified that the involuntary separation terms would have been comparable to those in the voluntary separation package. As such, the claimant was not at risk of losing all benefits. Accordingly, since the claimant quit in anticipation of discharge in order to accept a voluntary separation package, her resignation was on her own accord and without good cause connected with the work. We should therefore reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The decision should be affirmed. The greater weight of the evidence indicates that the claimant was separated because her position was being eliminated. The claimant and around 600 other employees who were all over the age of 55 were offered lump sum settlements because their positions were being eliminated as part of a mass layoff. The claimant's acceptance of a lump sum payment does not change the nature of the separation. As such, the claimant should remain qualified for benefits. Affirm the AT, no misconduct chargeback.
Reverse the AT, voluntary leaving, no chargeback, adequate response.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Alvarez.
Next case will be 246-0299. Commissioner Alvarez.
The decision should be reversed. The claimant denied that he was aggressive or insubordinate during the final incident. The employer provided only hearsay evidence. The claimant's supervisor approved the claimant's schedule, which a team lead subsequently changed. Consistent with President Appeal Number 4622-CA-76, the claimant's attempt to clarify contradictory instructions from the different managers was not misconduct connected with the work. Reverse the AT, no misconduct chargeback.
We should affirm the appeal tribunal decision. Because the claimant was argumentative with the team lead in front of coworkers, the claimant was subordinate and mismanaged his position of employment. We should affirm the AT decision. Misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Alvarez.
Next case will be 246-1735, Commissioner Alvarez.
The decision should be reversed. The employer discharged the claimant for alleged theft. The claimant denied the employer's allegations under oath. The employer had no firsthand testimony. Instead, the employer relied upon video evidence, which it failed to produce. Accordingly, the claimant's sworn testimony carries greater weight than the employer's hearsay. The employer's testimony is also inconsistent. If the claimant was hitting no sale on transactions as the employer described, it would not have created the type of register shortage described by the employer. The employer also presented testimony from a cook that the claimant turned in register overages. Hitting no sale on a transaction would create an overage. But if the claimant was stealing, she would pocket the overages. Not report the overages and turn them in to be stored in the safe. The evidence is insufficient to establish misconduct. Reverse the AT, no misconduct, chargeback, void response.
The AT decision should be modified. The claimant's self-serving denial is not credible when compared to the employer's clear, detailed, and unwavering testimony about the final incident. Moreover, the claimant did not provide any reason as to why the employer would fabricate statements about the claimant. Finally, the employer testified that the claimant began yelling at the employer when confronted with the theft allegations, and the claimant did not deny yelling at the employer. That conduct alone constitutes mismanagement of one's position of employment. Thus, since the evidence established that the claimant committed work-connected misconduct, we should modify the AT decision. Misconduct, no chargeback, sever the adequate response.
Reverse the AT, no misconduct, chargeback, void, adequate response.
A short form.
Thank you. I have a short form dissent with Commissioner Demerson.
Next case will be 246-2596, Commissioner Demerson.
The appeal tribunal decision should be modified. The preponderance of the evidence in this case establishes that the incident related to the claimant being absent from work, illness. As such, the claimant should continue to be qualified for benefits, and the employer's account should be protected from charge under a medical separation analysis. We should therefore modify the AT decision, no misconduct, no chargeback, MVI.
I would agree with Commissioner Demerson.
I concur.
Thank you. We have a unanimous decision.
Next case will be 246-3062, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant was separated from employment for refusing a drug test. The employer provided sworn testimony that the claimant would have known that stepping outside the drug testing facility would constitute a refusal. Since the claimant did not provide any testimony to contradict the employer's position, the greater weight of the evidence indicates that the claimant was terminated for work-connected misconduct. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, the commission should grant a rehearing to allow the employer to submit a copy of its drug testing policy and what constitutes a refusal thereunder.
The AT decision should be affirmed. The claimant was instructed to take a random drug test so that he could provide a testing sample. The claimant waited right outside the drug testing building to drink some water and smoke a cigarette. The general foreman was in the truck on the premises when this happened. There is no evidence that the claimant refused to take the test or was warned not to leave the building. The employer failed to establish misconduct credible or persuasive evidence. Affirm the AT, no misconduct, chargeback.
I would agree to rehear the case.
All right, we will rehear the case to obtain a copy of the drug testing policy.
Next case will be 246-3695, Commissioner Demerson.
The appeal tribunal decision should be affirmed. The claimant refused to comply with an employer directive to provide documentation verifying the reason she needed to miss work. The claimant stated since the documentation requested dealt with a relative, she was impeded from complying with the employer's instructions. However, the claimant stated in fact finding that she spoke to a doctor. The claimant could have asked if there was anything else the doctor could have provided in line with the employer's request, or the claimant could have redacted any sensitive information from the documents. If the employer is not allowed to verify the reasons for an employee's absence, it results in a scenario where employers will be unduly burdened in the event that employees are dishonest about their reasons for leave. As such, we should affirm the AT decision, misconduct, no chargeback.
The AT decision is not supportable and should be reversed. The claimant was discharged because she did not provide her grandfather's hospital discharge documentation to the employer, as the employer demanded of her. The claimant's grandfather refused to provide the documents, and the claimant did not have the authority to make him do so. Moreover, the employer's request was overreaching and unwarranted under the circumstances. The claimant requested to miss a few hours of work to bring her grandfather home from the hospital. She made the request in advance of her grandfather's discharge and only missed a few hours of work. It was unreasonable for the employer to demand from the claimant her grandfather's confidential medical documents to justify a minor adjustment to her work schedule. The claimant's failure to comply with the employer's unreasonable demand did not constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form.
Thank you. I have a short form dissent with Commissioner Demerson.
Next case is 2465000. Commissioner Demerson.
We should reverse the appeal tribunal decision. It is clear that the employer was initially confused about the paperwork involved in this case. However, a review of the testimony and documents established that the employer received no decision nor the hearing notice for the AT1. The evidence indicates that the employer first learned that was receiving benefits after the employer received a wage verification notice. The employer called TWC and learned that it had missed a hearing and that the AT reversed in favor of the claimant. The employer immediately filed an appeal. Because the employer did not receive the AT decision or notice of the first hearing, we should deem the employer's appeal timely, find that the employer had good cause for its non-appearance, and resubmit the case for merits testimony.
The AT decision should be affirmed. The employer filed a late petition to reopen. The employer was out of town during the appeal period. He was not consistently checking the mail himself and was uncertain about whether the decision was received. Therefore, the employer did not rebut the presumption of receipt. Affirm the AT late or employer petition to reopen, no misconduct, chargeback.
Reverse the AT, timely employer petition to reopen, resubmit.
Mr. Chairman, did you wish to make a vote on good cause as well, or shall we reverse only on timeliness and resubmit on remaining issues?
Resubmit on everything.
Thank you.
Next case will be 2465301. Commissioner Alvarez.
The claimant's appeal to the commission should be deemed timely. When the claimant sent in a premature appeal, Commission Appeals failed to send out notice that his appeal was premature. Instead, Commission Appeals sent out an acknowledgement letter during the appeal period, which explicitly stated that the premature appeal would be used as an appeal in this case. Given that Commission Appeals provided misinformation regarding the use of the premature correspondence as an appeal, the claimant's subsequent late appeal should be deemed timely. Deem the claimant's appeal timely and resubmit.
Accordingly, because the claimant was provided misinformation about his appeal rights, we should deem the claimant's appeal timely and resubmit for merits testimony.
Timely commission appeal, resubmit.
Thank you. We have a unanimous decision.
Next case will be 2468157. Commissioner Demerson.
Appeal tribunal decision should be modified. The claimant left work early before completing her job duties, with work still left to be done. The claimant abandoned her shift due to dissatisfaction with the workplace. The claimant stated that her supervisor said okay when she announced she was leaving, but the employer testified that the claimant was told it was not a good idea to walk off like that. Additionally, the employer's written statement and filed documents do not support that the claimant was told okay when she abruptly left work. In fact, one of the employer's witnesses statements mentions that the claimant left while food was still in the oven. The claimant's work before completing her duties under all of the circumstances constituted misconduct connected with work. We should therefore modify the AT decision, misconduct, no chargeback, sever the adequate response.
The AT should be reversed. Correction, the decision should be reversed. Although the claimant left work early, she gave notice to her supervisor. The claimant told her supervisor that she would be back the next day. The supervisor provided the claimant with the response that she reasonably understood to mean she had permission to leave, and that she expected her to come back the following day. Therefore, the claimant did not abandon her job, and the employer did not establish misconduct. Reverse the AT, no misconduct, chargeback, void, adequate response ruling.
Reverse the AT, no misconduct, chargeback, void, adequate response.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Demerson.
Next case is 246-9297, Commissioner Alvarez.
The decision should be reversed. The claimant worked as a forklift driver for the employer for 35 years. After being assigned to an unusual task, the claimant questioned the supervisor as to why he was assigned this task. The claimant presented testimony from multiple firsthand witnesses denying that the claimant was insubordinate or threatening. Both parties agreed that the claimant did not in fact perform the job duty assigned to him. A 35-year employee should have some right to question an unusual assignment. The claimant's actions did not rise to the level of misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
We should modify the appeal tribunal decision. The claimant engaged in a heated argument with the supervisors and refused to leave the office and return to work despite repeated instructions to do so. In fact, the coworker had to take hold of the claimant's arm and physically lead him out of the office. While the claimant eventually carried out the duties assigned, his hostile, argumentative, and insubordinate behavior constituted management of his position of employment. We should modify the T decision, misconduct, no chargeback, sever the adequate response ruling.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Next case will be 247-2746, Commissioner Alvarez.
The decision should be modified. The employer had good cause for their non-appearance. Regarding the job separation, the claimant briefly glanced at her phone from her pocket because she had received 7 or 8 life alert notifications about her 92-year-old grandfather. The claimant is the primary caretaker for her grandfather, and he had recently experienced a fall a few days before. The claimant needed to look at her phone to check on her grandfather and let paramedics into the house. It was also established that others had violated the cell phone policy by having phones out of the call center floor without being fired. Therefore, we should find no misconduct. Modify the AT. Employer had good cause for missing AT1. No misconduct, chargeback.
The AT decision should be modified. Regarding good cause, the employer did not appear at the hearing due to delayed receipt of the notice. Since the employer was unable to participate due to circumstances beyond its control, the employer established good cause for its non-appearance. As to the job separation, the claimant testified that she knew her job was in jeopardy when she admittedly used her phone on the call center floor in violation of policy. We should therefore modify the AT decision. The employer had good cause for its non-appearance, misconduct, no chargeback, adequate employer response ruling.
Modify the AT, employer established good cause for AT1, no misconduct, chargeback.
Short form.
Thank you. I have a short form dissent with Commissioner Demerson.
Next case will be 248-0328, Commissioner Alvarez.
The decision should be modified. Since January 2019, the claimant has worked on an irregular as-needed basis for the employer when events are available. As a part of his hiring agreement, the claimant was allowed to decline an event and continue to work future events. The claimant declined to work events for a day or two shortly before Thanksgiving because he was not given enough notice of the events and had family in town. The claimant worked the next available event in December and continues to work when it is available. Since the claimant accepted work pursuant to the terms of the hiring agreement and continues to work for the employer, there was no actual separation from employment and the continued claim work separation should be voided. The overpayment should be reversed. Modify the AT, void separation determination, no overpayment, sever the availability issue.
We should modify the AT decision. I agree that the availability issue should be severed. As to the job separation, the claimant did not pick up available assignments due to personal reasons, which is consistent with quitting voluntarily without good cause connected with the work. We should therefore modify the AT decision, voluntary leaving, overpayment of $2,889, and sever the availability issue.
Modify the AT, voluntary leaving, overpayment, sever availability issue.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Alvarez.
Last case would be 2480525, Commissioner Alvarez.
The AT's decision should be reversed. The claimant is unable to work full-time due to a disability and receiving SSDI. She has worked part-time for the last several years, including all of her base period. She continues to work on a part-time basis, consistent with the limitations imposed by her disability. Therefore, she should be held eligible under the provisions of Section 207.0211 as she was in her prior benefit year. Reverse the AT, the claimant is available for work.
The appeal tribunal decision should be affirmed. The preponderance of the evidence in this case indicates that the claimant was unwilling to accept full-time work because doing so would interfere with the government entitlement that she was receiving. As such, the claimant was unavailable for work. We should therefore affirm the AT decision, claimant unavailable beginning 12/08/2019.
Reverse the AT, claimant is available for.
Short form.
Thank you. I have a short form dissent with Commissioner Demerson, and that is the last case that was pulled for additional discussion on docket 17. You should have already received the short form dissent list for docket 17.
I move we accept staff recommendations on the remaining UI cases on docket 17.
I second the motion except for those cases on which I am dissenting as reflected on the UI short form dissent list for docket 17.
I concur with the chairman's motion except for the cases on which I am dissenting as reflected in the UI short form dissent list for docket 17.
Motion passes with the exceptions noted.
Thank you, sir.
Thank you. This brings us to the end of agenda items 3 through 7. Let's pause momentarily to reset for the rest of the meeting.
I can get up there and read this one.
All right.
You don't like the light off? Neither do I. Always go in there when you guys are out. I'm like,
Yeah,
I do the same thing. Can you imagine we get the more cases? And my back.
we may have to have separate commission meetings.
All right, let's move to agenda item 8. This is emergency UI rule. Discussion, consideration, possible action regarding adoption of emergency rules pursuant to Texas Government Code, section 2001.034 relating to certain unemployment provisions in Public Law 116-127, the Families First Coronavirus Response Act.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, I'm Jason Stalinsky, Unemployment Insurance Policy. The Emergency Unemployment Insurance Stabilization and Access Act provides states with emergency funding grants for the administration of their unemployment compensation programs. The purpose of these grants is to assist states with the unprecedented claim volumes associated with COVID-19. These grants are allocated into two separate allotments, Allotment 1 and 2. Each allotment contains its own requirements. If a state meets the requirements of and obtains both Allotment 1 and 2, the federal government will pay 100% of any extended benefits until the end of the year. A requirement of Allotment 1 is a state law requiring employers to provide an individual notification of the availability of unemployment compensation to employees at the time of separation from employment. The Commission has the authority under Texas Unemployment Compensation Act, or TUCA, Section 208001B, to require this individual notice. To clarify how this notice must be provided, today's staff is recommending amending Section 815.1 to define places accessible as stated in TUCA Chapter 208 to include general notice in the workplace and individual notice upon separation. Additionally, Section 209025 of TUCA provides the Commission with the ability to maximize the receipt of any fully funded federal extended benefits. TUCA currently provides for an insured unemployment rate, or IUR trigger, for extended benefits with benefit eligibility lasting a maximum of 13 weeks. Federal law, however, provides for an alternate trigger, the total unemployment rate, or TUR trigger. The TUR trigger also provides that in periods of high unemployment, an additional 7 weeks of extended benefits eligibility is available. To maximize the federal funding of extended benefits, the agency will need to implement the optional TUR trigger with the high unemployment rate period, as provided for in Chapter 815, Subchapter F of these proposed emergency rules. During the surge of unemployment, it is vital that Texans have prompt access to the full extent of extended benefits available. Therefore, staff requests the Commissioners find imminent peril to the public welfare, which requires the adoption of emergency rules without 30 days notice in the Texas Register. On the same basis, staff also requests the Commissioners find imminent peril to the public welfare requires the adoption of rules with an expedited effective date that is effective immediately upon filing with the Secretary of State, so that these rules can be implemented immediately under the emergency rulemaking provisions of Texas Government Code Sections 2001-034 and 2001-036. Staff will bring forward permanent rules to replace these emergency rules at a later date. Today, staff is seeking your direction on submitting these proposed rules to the Texas Register. If so directed, staff seeks approval to make any minor non-substantive corrections to the document for purposes of publication. I am here this morning as resource to answer any questions.
Yep. Comments or questions?
Chairman, am I correct that there will be 2 motions on this specific agenda item?
I believe that's correct.
Okay. No questions.
Commissioner Demerson,
None here.
are there any motions?
Yes, sir. On the first motion, on March 18, 2020, the federal government passed the Emergency Unemployment Insurance Stabilization and Access Act of 2020. Emergency rules are necessary to implement the act and provide Texans with the prompt and extended financial assistance, which will also serve as a stabilization factor in our local economies, both of which are critically needed due to the statewide disruptions caused by COVID-19 global pandemic. I move that the Commission formally find that immediate action is required to comply with the requirements of the Emergency Unemployment Insurance Stabilization and Access Act of 2020 and avoid the imminent peril to the public welfare that would be occasioned by delay.
I second the motion.
It's been moved and seconded. We're unanimous.
Yeah. Oh, I second that. I'm sorry. Well, I made the motion.
You did. We're good.
You want me to read? I'm sorry. I had a break up there. I apologize for that.
Not at all.
My second motion, I also move that we adopt the emergency basis. On the emergency basis, pursuant to the Texas Government Code Section 2001.034, the proposed amendments to Chapter 815 rules relating to the unemployment insurance benefits general provisions in Section 815.1 and extended benefits in Sections 815.170 through 815.174, and publish them in the Texas Register with permission for the staff to make minor non-substantive changes.
Good. Mr. Chairman, I'm going to second the motion. Before that, I do that, I want to make sure, Ed, that we have an opportunity to work with you guys on any thing that we need to get out to the Texas employers in regards to what we're establishing here. We'd love to work with you to share that information.
Yes, sir. We absolutely will make sure that you have that opportunity. This just allows us to be able to move in that direction.
I'm still reading
Okay.
this thing.
Good. With that, a second.
It's been moved and seconded. We're unanimous.
Thank you, Commissioners.
Thank you. I'm showing no reports for agenda item 9. Agenda item 10 is disaster relief. This will be discussion, consideration, and possible action regarding guidance on resource utilization and implementation of services and strategies to target disaster relief efforts and public health emergencies with the Department of Labor's Disaster Dislocated Worker Grant. Item 10A, COVID-19 essential workers allowing providers to charge the difference, discussion paper.
Good morning, Chair Daniel and Commissioners. Reagan Miller for the record. This morning for your consideration is a state rule waiver request concerning whether child care providers can charge an essential worker the difference between the board's reimbursement rate and the provider's published rate, which is sometimes referred to as their private pay rate. Providers have brought to our attention that they were previously serving the children of parents who were now classified as a TWC COVID essential worker. These TWC COVID essential workers now qualify for 3 months of TWC COVID essential worker childcare. In cases where the board's reimbursement rate is lower than the provider's published rate, the provider will receive less revenue for serving the same child. So while COVID essential worker childcare was a benefit to the parent, it could be a detriment to the provider in these specific cases where they were already serving the same child at a higher rate. This morning, we're seeking your direction in pursuing a state rule waiver to allow providers to charge the difference only for those families that were previously private pay and continue to be served by the same provider as a COVID essential worker through 2 state waiver requests. First, a waiver of TWC Child Care Rule, Section 809.92, which prohibits providers from charging the difference to protective services families. This waiver request would allow charging the difference in the scenario previously described. And secondly, a waiver of TWC Child Care Rule, Section 809.13C11, which requires boards to adopt a policy in an open meeting regarding charging the difference, and instead to establish a statewide policy for COVID essential workers who were previously private pay, as described a few minutes ago in those specific instances.
Sure they have.
Happy to answer any questions.
Mr. Chairman, I have a question.
Yes.
Reagan, again, great work. Super excited that we're facilitating the needs of our essential workers. So thank you for that. The only question I have is, when would these waivers be effective?
We are thinking that we could make the waivers effective on April 1st when we started enrolling new parents in essential worker childcare to allow providers to make up that difference. Again, for parents, they would still be paying a much lower amount than they were as a private pay parent.
Great. Thank you, Reagan.
Yes.
Comments or questions?
Not here.
None. Are there any motions?
Yes, Chairman. I move that we waive Section 809.92C to allow providers to charge the difference to the families that were previously private pay and continue to be served by providers as COVID-19 frontline essential workers, and that we waive Section 209.13C11 to allow for the statewide policy for providers to charge the difference for COVID-19 frontline essential workers who were previously private pay, as described in the discussion paper.
Second.
It's been moved and seconded. We're unanimous.
Thank you, Commissioners.
I noticed it wasn't on the discussion paper. Even on the 24th, we didn't have a date.
All right, do we have anything else under agenda item 10?
We should have an update from Clay Cole.
All right.
Good morning, Commissioner Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Cerner. For the record, Clay Cole, UI Division. This week, again, seeing big payouts and UI benefits. We continue to add and increase system capacity. All 4 call centers partners are online. Majority continue to ramp up our numbers. Again, just increasing our capacity. Today, UI is having a kickoff with Genesis to begin work to deploy a cloud interactive voice response system, allowing UI to process more payment requests on teleserve and increase capacity to eliminate busy signals and use artificial intelligence to help with servicing customers. We continue to onboard external volunteers. We have begun providing new assignments to Senate and House volunteers, outreaching customers in efforts to reassure our customers of their claim status and help reduce calls to our call centers and just provide better customer resolution and next steps. UI is working closely with finance and operational insights who are helping perform data analytics on customer groups to streamline assignment processes and improve messaging. We also are exploring plans for having our own or a partner call center work as an outbound call center to reach customers needing specific high-need services, which will help achieve greater resolution, reducing unnecessary callbacks. UI is actively working on plans for Texas opening back up for business by exploring options for streamlining communications and handling cases with employers and customers returning to work that aligns with the governor's plan released yesterday. And again, we've seen big improvements in our assignment productivity, especially specific assignments that we see high numbers in. We refer to as EDO2, CT10s, but just want to give a big shout out and thanks to our internal volunteers because they're really helping us really increase our productivity. So big thanks to all our TWC volunteers for helping UI during this, big need for our customers. And this concludes my update.
Thank you, Clay. Commissioners, comments or questions?
Chairman, I'd just like to take this opportunity to thank Clay, his staff, and those that have volunteered for all they're doing during this time, in taking time to answer questions, extending the hours of operation, and many of those who work on the weekend. So I just wanted to take this opportunity to thank Clay, his staff, Lachey as well, for their continued support.
Thanks, Commissioner.
And I'd like to also, Mr. Chairman, Commissioner Alvarez, echo those sentiments. We appreciate the work that's been done day in and day out, and a lot of stars, Clay, you guys have on that team. I won't call out all the individuals, but help when we're going to them for assistance, and that means a lot. And so we really appreciate that.
Awesome.
Question on the outbound call centers. So when do we expect to have that up and running, or that activity taking place?
We haven't set a date, but we hope to as early as next week, sometime hopefully have a plan in place. We're still working on the data analytics to zero in some of those high customer needs of service. And so as soon as we have that, we'll let you know.
Okay, and just going to overemphasize that's the busy signals and the things along those lines. We're eliminating those things. We're making a lot of progress. And again, appreciate all the work that you guys are doing, and those kind of initiatives allow us to move even faster. So applaud the efforts on data analytics and the like to make sure that we're addressing the needs of folks that are out there.
Thanks, Commissioner.
One thing just to clarify, commissioners, Clay was talking about, I know you all understand, but just to make sure that it's clear, we're talking about dedicating one of our call centers for outbound, but we are making outbound calls now with staff and with outside volunteers that are reaching out to our customers to get clarification or to get information. So we're doing some of that with the volunteers. This would actually be taking one of our call centers and converting it to outbound versus inbound to be even more effective.
Strategy behind that, then, that we've been able to confirm that there's a number of people who are still calling the claims line because they have questions even after their claim being perfected and filed.
Yes, sir. That's exactly right. And the assistance that we're getting now with the volunteers, they have limited, they've developed a good understanding, but they have limited understanding of the details of the unemployment system. And if we take one of our experienced call centers and have them make outbound calls, then when we make those calls, we can completely resolve any issues or questions that the individuals may have.
Excellent, excellent.
Mr. Chairman,
I do really perceive that as a good use of our resources. And I would say, Clay, to you, and certainly Mr. Cerna, we have done a remarkable job of staying abreast of changing issues as they've moved through the UI claims process. A large number of people trying to get through. I know we've taken a number of measures to address that. are moved it to 7 days a week, 12 hours a day, which still leaves the computer time to process overnight. I think we've done a good job of reallocating TWC staff and volunteers. Of course, our House and Senate staffers are providing, I think, a great service to us in terms of outbound calls and the ability to reach customers who simply have a question, even after their claim has been taken and in some cases even authorized for payment. I know questions persist. And so these efforts are taken then in an effort to not have to have people call the 800 number where you would also call to be able to get your claim. Now, that's sort of goes along with the fact that, you know, we've seen a great increase in our computing capability and that 90%, maybe greater than 90% of our claims are still coming in online. Is that still correct?
Yes, sir, it is.
Okay, so we've deployed a number of tools then to help our UI team, and I anticipate that we'll continue to apply that kind of creativity. So kudos to all who are looking at creative ways to help us communicate with all of our customers more effectively, and hopefully we'll be able to figure out a system to address each of these new issues as they come up.
This is where I take action and do it. Or is it after exec?
All right, thank you. Anything else under agenda item 10? No. Let's move then to agenda item 11. This is discussion, consideration, and possible action regarding approval of local workforce development board nominees.
Good morning, everybody. Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Serna.
Morning.
For the record, Shanta Williams with the Workforce Development Division. And before you for consideration, we have workforce board nominees for Workforce Solutions Capital Area, Concho Valley, Heart of Texas, and Northeast Texas. And staff recommends that all nominees be approved, and I'm here to answer any questions you may have.
Commissioners, comments or questions?
No, sir.
None here.
Thank you. Do we have a motion?
Chairman, I move that we approve the board nominees for Capital Area, Concho Valley, Heart of Texas, and Northeast Texas.
Second.
It's been moved and seconded. We're unanimous.
Thank you.
All right. Tom, do you have anything to report today?
Yes, sir. Good morning, Mr. Chairman, Commissioner Alvarez, Commissioner Demerson. For the record, Tom McCarty, External Relations. Last Friday, the President signed into law HR 266, the Paycheck Protection Program and Healthcare Enhancement Act. This is one of the another part of the stimulus package that they've passed. It provides $310 billion for the depleted Paycheck Protection Program, with $60 billion of the $310 being set aside for underbanked businesses. There's also $60 billion in loans and grants for economic disaster assistance, $75 billion provided for hospitals, and $25 billion for coronavirus testing. Congress is currently in recess this week, and both the U.S. House and Senate will return on May 4th. This concludes my remarks, and I'm happy to answer any questions you may have.
Answer questions?
No, Chairman.
Commissioner Demerson?
None here. Thank you.
Thank you very much. Tom, thank you.
Thank you, sir.
Ed, anything on the executive director's report?
Just one brief thing I want to make sure the commissioners are aware of. We continue to pay attention to the UI issue, the number of calls, the resources that we're putting there, et cetera, but we are also beginning to focus our attention on the recovery and the recovery of the economy. To that end, we have already begun taking steps to increase the bandwidth, if you will, of Work in Texas. We currently can handle 25,000 concurrent users. We'll be taking steps to increase that by 5 times. So we can handle over 100,000 concurrent users in the very near future. So we're anticipating the demand shifting over there, and we're taking steps well in advance to address that. And we'll continue to inform your offices, brief you all, and take steps that are necessary to serve those customers as well.
Right. Thank you, Ed. Commissioners, comments or questions?
Not to Ed, sir.
Mr. Chairman, yeah, to Ed, I applaud those efforts on WIT because that will be the next step. And so a lot of those claims will go into that website. And I know Heather and her team done amazing work on getting that up. And so to putting that out there so that job seekers and employers have an opportunity to post jobs on that in an easy way, and those job seekers have a very easy way to find those opportunities that are out there. And that lines up with the governor kind of announcing those jobs that are out there and those workforce boards in the positions that they have and what they're going to do. So appreciate you guys.
Sure, thank you.
That will be the next level, WIT.
We'll be ready.
Right. Ed, thank you. You know, with regard to the governor's announcement yesterday and the phased reopening of the state, which is definitely moving us back to opportunities for people to go back to work. I think, Ed, related to what you're talking about with regard to work in Texas, I do think it creates a couple of additional opportunities for folks as they're re-entering the workforce. One's a technical issue, and the other, I think, is an opportunity for a number of people. The technical issue would be, if there's no objection from the commissioners, I'd ask staff to be prepared at the next commission meeting to talk to us about some of our UI rules that have been suspended, work search, other rules that we have suspended. I'd like to have a report next week on where we are with those rules and what our plans are as we move back toward a more typical UI program, and what we think our timeline is for that, particularly with people that are going to be moving in and possibly still out of the workforce. I just would like a greater understanding of that. So if there's no objection, I'd ask staff to do that next week.
I should recommend as far as
No objection. And then the second point that I would make is this. You know, I think that with businesses being able to reopen on a more limited basis, you know, some with limited capacity based on their total capacity of people, obviously some sole proprietors and others that are able to go back to work on Friday, and I think some additional hospitality sector industry being able to go back to work on a limited basis. We're not going to have everybody start back at once. Ed, if it's, I think it's possible to do this by Zoom, and if there's no objection from commissioners, I'd ask staff to be able to report back to us at the next commission meeting in terms of what we've done thus far in terms of creating training opportunities and other opportunities related to training for Texans who are either on unemployment or are seeking to avoid going on unemployment by taking advantage of those opportunities. And then what our midterm plan is for helping people upskill or in general, you know, be able to find jobs suitable for their training as they re-enter the workforce. And so,
Yes,
if there's
sir.
no objection from the commissioners, I'd ask staff to report back to us on that at the next scheduled commission meeting.
Chairman, I am totally in agreement with that. The only thing I would ask is prior to our Tuesday commission meeting, if there's an opportunity for staff, whether it's through a Zoom or another media source, if we could have those conversations with staff. But I totally agree with you, and I think this is a great recommendation.
On board.
Yes, sir. We'll be able to do that. You'll notice Courtney and Cheryl didn't have anything to report this week. I've already been talking to Courtney about her getting more of that information to you all, so we will definitely be prepared to do both of those things next week.
Wonderful.
And we'll provide information to the offices between now and then.
Thank you, Ed.
Okay. Very good. And I know you guys have been working on these things, and we've had several people working on them. I think now's an appropriate time for us to consolidate these things and be able to talk to Texans about what opportunities are available for training, and then just what options are available as folks are wanting to re-enter the workforce. Great. Anything else?
No, sir, I have nothing else. Thank you.
Okay, great. The time is now 10:19. The Texas Workforce Commission is now going into executive session pursuant to Texas Government Code Section 51.0711 concerning pending litigation titled CareFlight versus Texas Workforce Commission and Michael Lichtig, and to discuss the appointment, evaluation, reassignment duties, discipline, or dismissal of the executive internal auditor, executive staff, and other personnel pursuant to Texas Government Code Section 551.074A1.
right, looks like Zoom is working.
I'm live.
Live. It's live.
Julia?
Commissioner Alvarez is
You are good.
Are we good to go?
You are good to go.
Mr. Trotman, are you in place?
I'm gonna go ahead.
Is there?
Les.
Yes, sir. I'm right here.
Okay, great. The executive section has now concluded. The time is 11:23 a.m. Is there any other order of business to come before the commission?
Chairman, I failed during the docket period of our meeting to acknowledge, if I may. I have a comment regarding today, April 28th is the National Workers Memorial Day. And I'm just asked that we reflect on those individuals who lost their lives during their work. So I just wanted to make that comment. So thank you for allowing me to do so.
An appropriate comment. Thank you, Commissioner Alvarez. Any other item to come before the commission? Hearing none, is there a motion to adjourn?
Chairman, I move that we adjourn.
I second that motion.
It's been moved and seconded. We're unanimous and we're adjourned. Thank you all.
Thank you, guys.